Well, we'll proceed to the final matter, which is Metivier versus Lockheed Martin et al. Prime versus Lockheed Martin et al. And weeks. And this is numbers 35 of 2020, 36 of 2020, and 37 of 2020. So for the appellant, do you wish to reserve some time, Dr. Johnson?
Yes, Your Honor, 5 minutes, please.
Okay, 5 minutes. And you will be arguing on behalf of all three?
Correct, Your Honor.
Very well. You may proceed.
Mr. Chief Justice, Associate Justices, and may it please the Court, Jacob Gower on behalf of the appellants. The Superior Court erred as a matter of law when it concluded that a Rule 25 motion to substitute is not subject to the tolling components of Rule 6b(1) of the Virgin Islands Rules of Civil Procedure. If the Superior Court's decision stands, then the Virgin Islands has retreated to pre-1963 jurisprudence, particularly the Anderson decision, which the Superior Court noted was based on one of the worst rules of civil procedure, and that's the former Federal Rule 25, which was incredibly unforgiving. Under this modern version of Anderson, no amount of good cause or excusable neglect can ever resuscitate a case when substitution wasn't perfected within 2 years. It matters not whether the heir is incapacitated. It would matter not whether or not the heir is a minor. It wouldn't matter if the heir doesn't know of their relative's passing. It wouldn't matter if the heir doesn't know that their relative had a lawsuit or had any patrimony. It wouldn't matter if the heir doesn't understand or know about their obligations to timely substitution within 2 years. It wouldn't matter whether or not the heir is represented by counsel or lacks any legal education, as if they were proceeding pro se. And then focusing on the particulars of this case, it wouldn't matter whether or not there's been any appreciable action in the litigation in more than a decade. For example, it wouldn't matter whether or not a case management order had entered. It wouldn't matter whether or not the litigants have been waiting for rulings on dispositive motions for more than 6 years. Ultimately, Rule 25 doesn't compel this result. It wouldn't compel any of these results. Rule 6b(1) offers a clear opportunity for the court to be able to step in and exercise its equitable authorities upon the proper showing to the court of good cause.
Would it matter if, to commence the case in the first instance on the 2-year statute of limitations, would any of those things matter if a person didn't file it within 2 years? And ask the court to, extend the statute?
I don't know if I fully understand your question. Are you talking about?
My question is, you said, my question initially in starting the case, would any of those things, whether a person was a minor, would those matter if you didn't file it on time?
I think in the instance of incapacity and being a minor, I think it would. I don't think the statute of limitations would run in that instance. I also think that, as this court, or at least the Superior Court has made clear, is that the Virgin Islands, the sound rule for the Virgin Islands is to recognize that there is things like class tolling, there is the discovery rule, there are equitable exceptions to traditional statutes of limitation. So, yes, Your Honor, some of these things.
My question is, why isn't 2 years after the death of someone sufficient? And if 2 years passes and there's no substitution, why isn't it just as fair as when you have the obligation to commence the case initially within 2 years?
Well, I think that the situation here is, Your Honor, let me put it in the specific context of Ms. Khan. Ms. Khan didn't know that her father had a lawsuit. And so there was no real opportunity from her perspective to step into the shoes of her late father and to be able to take over the reins of that case. It was only after about 2 years, 6 months or so that, Attorney Alcon, who was representing her late father prior to his passing, made contact and sort of that connection was made, and then a motion was filed. In that case, it's just as simply she wasn't aware of the 2 years and didn't know that any action was necessary to preserve that right.
Well, your argument is that the Rule 6B, you're trying to use Rule 6B to extend the time limits that have been imposed by the statute. Isn't Rule 6B usually used to extend time limits that are imposed by other rules?
Yes, Your Honor. So Rule 6B would be enlarge the time for something that's subject to, one of the other rules that's in the Rules of Civil Procedure. We've operated from the presumption that Rule 25 operates not necessarily to the exclusion of Section 77 and Section 78, but Rule 25 was the operative provision by which plaintiffs, the plaintiffs or the appellants sought relief before the Superior Court. So it was a rule-based action rather than a statutory-based permission that was requested.
But if the rule is identical to the statute, can you basically get around the statute by going under the rule?
Maybe, Your Honor. And I think that the discrepancy here is that this court, as well as the Virgin Islands legislature, have the concurrent authority to engage in rulemaking. And I think Judge Willox aptly notes that in the Jones decision, where he talks about the history of the Revised Organic Act. So I think this court, though, could recognize that it is engaging in a concurrent rulemaking authority, but there really is no conflict here. If you look at Section 78, it includes both a substantive component and a procedural component. The substantive component says that your cause of action doesn't expire at death. The second part of that is really a procedural aspect. It doesn't read like a traditional statute of limitations, but it reads like procedure. And the history of that rule is somewhat important insofar as if you look back to whence that came, back to Oregon and Alaska, these were seen as rules of procedure that predated sort of the actions, or sorry, the actions that many courts took subsequent to that to create their own rules of procedure. Procedural rules, but back in the day, many times were enacted by the legislatures. But at bottom, I think the court should not really see that there's a conflict between the two, that there is a clear resolution. It need not choose one or the other. But dismissal is not compelled by the statute, ultimately.
How about this case, this court's case, Hodge versus McGowan, where the court basically said that substitution had to be brought within the 2-year period?
Correct, Your Honor. So the dichotomy of the issue that was being resolved in Hodge was whether or not to apply the local rule or the federal rule. And so in that case, you were looking at Section 78 versus a federal statute. The court was not confronted with the current language of Rule 25. That's the first part. Second, no motion to substitute was ever filed in Hodge. Even after the decision, even on appeal, no motion was ever filed. And then most critically is that Rule 6B is never addressed squarely by this court in Hodge. And as Judge Malloy and Judge Willox both recognize, is that this court did not squarely confront that issue in Hodge, mainly because it wasn't brought to this court about whether or not 6B has any role to play in a late substitution. Your Honor, I want to kind of redirect our attention to what we think that the major issue is, and that's the 6B analysis was not fairly or faithfully followed, or the 6B procedures and factors were not faithfully followed by the Superior Court. And so I'd focus the court's attention to specifically to paragraph 45 of the opinion from the Superior Court, where it recognized that if good cause were a factor, then Tamika Khan, the appellant in Mr. Weeks's case, may have shown it. But just 3 sentences later, the court then concludes that 2 years is enough, and 5 sentences later reiterates that Rule 6B1 doesn't apply. So for the remedy, what we ask for is a remand to the Superior Court with instructions to take the rubric of 6B1, the 6 to 8 factors that it enumerates, go through each of those one by one, have an evidentiary hearing where all of the facts may be adduced on the record about why substitution did not happen within 2 years. And if the appellates lose, the appellates lose. But at least there's a full exposition of all the various factors and at least an effort to try to resolve these cases on the merits rather than a procedural defect, as we would characterize that here.
So you're basically asking us to disregard the holding that the 2 years is basically like a statute of limitations, and the judge actually so concluded, and then just went on to say, well, assuming that it wasn't a statute of limitations, and that the procedural rule applied, so he could consider the motion. So he just asked us to disregard that, stick strictly with the rule, and require a hearing, basically.
No, Your Honor. So what I'd like you to do is just faithfully follow 6B1. 6B1 says that you can enlarge the time except for enumerated exceptions. Rule 25 is not an enumerated exception.
And you believe that those exceptions are, cut and dry, and there's no room for expansion?
I think there would be room for expansion if there was a clear textual commitment in some other rule that says you can't. This is a hard and fast rule. It's a statute of repose. For example, Your Honor, if I may indulge with the time of passing, former Rule 6B1 specifically carved out Rule 25 motions. That rule was changed back in 1963. That provision was specifically excised. So when this court had an option of what 6B1 sort of iteration it could choose a specific Rule 25 carve out, or it could choose a provision without a Rule 25 carve out. This court deliberately chose the modern statute that does not carve out.
The carve out was a totally different rule, though. That was a rule that says, you had 90 days basically to substitute.
No, I'm not talking about the federal rule of substitution, Your Honor. I'm talking about the federal rule 6B1, or the federal counterpart to Rule 6B, not the substitution provision of Rule 25. You're right, Your Honor. I don't want to take the court down that rabbit hole, but Rule 6B.
When it carved out 25, at that time the rule was a very strict rule, correct?
Correct, Your Honor, it was.
Okay. All right, thank you. Attorney Johnson?
Good.
Just for the timekeeper, you will be arguing for 10 minutes?
I'll be arguing for 10 minutes total, Your Honor, and I'd like to reserve 4 minutes of that time for rebuttal.
Okay, who are you representing?
I'm representing Lockheed Martin Corporation, Justice Hodge.
You get rebuttal?
I
didn't think that the appellees get rebuttal.
I did think I got to reserve time, Your Honor.
What?
I did believe I got to get to reserve time, Your Honor, to respond.
As an appellee? I don't think.
Well, that's what I was requesting, but if the court will require me to give all the time up front, I have no problem with that either.
Yeah, you have to, because you only get to argue once as the appellee.
Understood, Your Honor.
So you may proceed. We'll give you 2 minutes as usual.
May it please the court. As a threshold matter, the notice of appeal in this case was filed out of time. The court's order, the memorandum opinion of Judge Malloy, was issued on April 26, 2020, and the notice of appeal was filed on May 29th, 2020. So I'd like to raise and preserve that for the record for the court, as jurisdiction, of course, can be raised at any time. And that, of course, is in violation of Rule 5 of the VI Rules of Appellate Procedure.
And did you raise that below?
We did not raise it below, Your Honor. In preparing, but jurisdiction, of course, can be raised at any time, and so we are raising it now. These are not cases of near misses. These are cases of extreme inexcusable neglect. In this case, the court heard all arguments on these motions, and there were no facts in dispute. Appellates don't argue that the motions for substitution were filed out of time. Lockheed and Glencore timely opposed. There's no argument that substitution of a deceased party must occur within 2 years of death. This court in Hodge versus McGowan held very clearly that substitution of a deceased party must occur within 2 years. If Section 78 of Title V is reviewed like a statute of limitations, as the court held in Jones versus Lockheed under Judge Willox and Martin versus Hovenza under Judge Malloy, then there is no discretion in the statute itself to determine or consider good cause or excusable neglect. Moreover, the statute is in derogation of the common law. At common law, all personal injury or tort actions abated when the person died. Statutes that are in derogation of the common law must be strictly construed. And in this case, as the district court held in Richards versus Nolan Associates, relying on Hodge, there is no discretion to consider good cause or inexcusable neglect. What the appellant is asking is for an evidentiary hearing where there are no disputed dispositive facts. That would result in a slippery slope. Every single motion for extension of time, for a late motion, for a late filing, would be entitled to an evidentiary hearing on the record. That is simply an absurd result that would be completely inefficient for the court and clogs the court's docket. Additionally,
Where it requires specific.
Attorney, I have a burning question.
sure.
Do you recall when the Virgin Island Rules of Civil Procedure went into effect?
2017, March 2017.
And that would be after our opinion in McGowan, am I correct? McGowan was done in 2008.
Correct, Your Honor.
Correct?
Correct,
Okay,
Your Honor.
November 10, 2008. Well, look at it this way. So the Virgin Island Rules of Civil Procedure came into being after McGowan, and the Rule 25 talks in terms of the substitution of the parties. And I noticed that the language in that use a lot of may, M-A-Y. A motion for substitution may be made by any party or by the decedent, successor, or representative. The motion may be granted at any time within 2 years after death. All right. Well, we have that Rule 25, but look at what Rule 6 did. Look what Rule 6 did. Rule 6B1, and I think that the plaintiff them made us a good argument when they said that because it says the court may, upon a showing of good cause or excusable neglect, extend the date for doing that act. The court may consider whether the request to extend the time is made before or after the required date. The reason for the movement's delay, whether for the reason for delay was within the reasonable control of the movement, and then it sets out all these things. And then they get to the crucial thing here where they have the exception. And I believe that plaintiff's attorney made a strong argument where the rules set out to say what rules are accepted from Rule 6B1. And he's absolutely correct that the Rule 25 substitution of parties is not included. If it's not included or excluded, couldn't the argument be made that that was not just a fleeting or inadvertence or happenstance, that it was a deliberate thing to make an exception? Where are you going to make exceptions? And you have Rule 50B, 52, 59, and 60B. That go to old-fashioned 60B. You made all of those rules exception to Rule 26.
Let me interrupt really quickly, Your Honor, there. Your Honor, very critically with this opinion, and this is why this opinion in part is so brilliantly written, is that it's not only about Rule 25. The legislature codified 5 VIC Section 78. There is a statute. There's a statute at play, and Judge Malloy's opinion incorporates both. To say that Rule 6B now provides discretion where the statute does not, right?
Yeah,
and the legislature essentially determines
but you see,
the court's jurisdiction.
The statute.
Be very careful,
if you will
because the court, because for all intents and purposes, the statute 5 VIC 78. Yeah, I know it talk about substitution of parties. Then what you're simply saying is that which one would take precedent in a case like this? Is it the rules, the Virgin Island Rules of Civil Procedure, Rule 25 and Rule 26? Or do we say that we cling tenaciously to 5 VIC 78, the substitution of parties, where it says that in the case of death or disability of the party, the court may at any time within 2 years on motion allow the action to continue or against a personal representative or successor in interest. So then what you're saying then is that if we're going to have that, then we don't need a Rule 6.
Well, what I'm saying is that the statute says what it says. The statute says
the
2 years.
upshot of that is that if you cling tenaciously and go with 5 VIC 78, then there could never be a substitution beyond within the 2 years, well, and which were not the intent of the Virgin Island rules of civil procedure.
There could, under certain narrow circumstances, and Attorney Gower raised that in his direct, such as equitable tolling. But equitable tolling has been argued in this appeal.
Attorney Johnson, I just was about to ask you that. If it's a statute,
yes.
You were just about, I think, to address the point that I was going to ask you about. If it's a statute, the statute would require the court then to interpret the statute. In other words, it would require statutory interpretation. The result could be then equitable tolling, would it not?
It could be, but equitable tolling has a standard that hasn't been argued here. And an equitable tolling...
I understand that.
Yes.
You brought up the statute, or you're saying the court didn't have any discretion. The rule, however, is very, very similar to the statute. If the statute can be tolled equitably, why can't you have the same flexibility with the rule?
Well, for one, the statute would govern, and that has been our argument from the beginning. The statute hasn't been repealed. The statute essentially works in conjunction with the rule. They're sort of belts and suspenders. The statute was designed to be congruent with the rule.
How do you respond to your counsel's argument that the statute is part procedural and part substance? And the substantive part, he says, is that the death of a party does not suspend the case. The case continues. And the procedural part is that you got 2 years in which to do it. And the law that this court has decided and was followed by 2 judges on the Superior Court he mentioned, that says that where there is a procedural matter and the legislature have spoken on the procedure and this court has spoken on the procedure, that this court's pronouncement will prevail. So if in fact that portion is procedural and Rule 6 has been adopted by this court, governing the practice and procedure which this court is authorized to do, why wouldn't that rule control?
I agree that the court has the discretion to determine procedurally whether it can be told or not, right? I do agree with that. But my argument is that the weight of case law provides that tolling comes in a context. And that tolling here is equitable tolling. And let me add one other thing, Your Honor, because I see my time is lapsing. In addition, this case considered both excusable neglect and good cause. In Metivier, the court, even though it didn't have to, went through an analysis and determined that the motion for substitution that was filed over 5 years later, that there was no good cause for it. That Metivier had lost contact, that the counsel had lost contact with the widow, and that there were other means for the plaintiff's counsel to communicate with the family. Very similar in Weeks. In Weeks, Tamika did not argue good cause, and the court ran through how the substitutor didn't argue good cause and waived good cause in her initial motion. Very similar in Prime. That involved a 10-year delay when the motion for substitution was filed almost a decade after the death. So even though that Rule 6 didn't apply and excusable neglect wasn't a part of the analysis, a required part of the analysis, the court still went through that process and found that it was just simply not good enough.
But the court relied specifically on the length of time, correct? And
not at all. In some, there was the question of waiver, right? Because and that goes back to very fundamental principles where in one of the cases, for example, the substitutor failed to disclose that the date of the death. And the court noted that it seemed like they were trying to sort of mislead the court. and then failed to raise it on their initial briefs and only raised it on their reply, thereby waiving that argument. Later upon that, Your Honor.
Then the court also said, well, he didn't even have a client, so therefore he wasn't even the attorney in the case. So, I mean, how can you have it both ways? You know?
Well, part of it is this. That one of the things that Attorney Gower argued is how bad Rule 25 was. But that Rule 25 under the federal rules only gave 90 days. All the case law below, case law in other jurisdictions that holds that there's a 2-year period,
Yeah,
that cases can't be interminable.
90 days from the suggestion of death on the record. You know, whereas here there's never been a suggestion of death on the record. Correct?
Well, the rule doesn't require this rule. As a matter of fact,
but you're referring back to the 90 days.
Rules does.
But the 90 days,
Your Honor, is that this rule is so permissive. Under the old rule, a probate estate had to be opened up. This rule requires a 2-page motion. That's a very low standard in a very long time. There has to be a point where these cases, like all statute of limitations, are honored and end. Otherwise, they can go on forever.
okay, thank you.
Thank you.
And your co-counsel?
Oh, yeah,
Morning.
Attorney Hunter? Yes. You have 5 minutes, so you may put.
Okay, thank you, Your Honor. I represent Glencore in the Weeks case only. I'd like to point out in the Weeks case, as well as apparently in the other two, the notice of appeal was not filed within 30 days of Judge Malloy's dismissal of the case on April 26, 2020. We rely on Hodge versus McGowan, Sweeney versus Hombres, and Richards versus Nolan and Associates with respect to the 2-year period after date of death of a litigant for substitution. It's our view that Rule 6B cannot amend the statutory 2-year period that is in Title V, VIC Section 78. And the argument presented by the appellant that you need to cut that statute in 2 halves, one substantive, one procedural. I disagree with their characterization as the provisions of the 2-year period being a matter of procedure rather than substance. We believe that an evidentiary hearing was not required here. There was a hearing on the motion, and I don't believe that there was another request during that hearing for an evidentiary hearing, although it was requested in the initial motion, in the second motion that was filed by the appellant in the Weeks case. With respect to the requirement of an evidentiary hearing, we rely on Rivera Marino and on 3RC and Company versus Poins Trucking. I think a critical issue here, Your Honor, that is dispositive of the Weeks appeal is that it is clear from Judge Malloy's written opinion, which is extremely thorough, that he...
Let me just ask you before you,
Yes.
so we can get this timeliness issue out of the way. During this period, was there administrative order issued by this court that extended the deadlines to 6/15?
I recall there were orders extending deadlines, Your Honor, and I haven't checked the
Did you
applicability.
check those?
I haven't
Okay.
checked it.
All right, thank you.
Yes. All right, so turning to Judge Malloy's opinion on Joint Appendix pages 31 and 32 in the Weeks case, it's clear when you read through this, when he discusses this case, that he assumed the truth of the affidavit filed by the appellant as an attachment to the motion to substitute the estate. So if there's no factual issue in dispute from the perspective of the court, there's no need for an evidentiary hearing. And the appellant has the burden in this appeal, Your Honor, in the Weeks case, to show that Judge Malloy abused his discretion under Rule 6 in denying an extension of time and abused his discretion in evaluating the facts that were asserted by the appellant and which he assumed was true.
But did the judge make findings of fact in which he determined that good cause wasn't shown?
Implicitly, he did. Yeah, he said that.
So did the parties have a chance to rebut those, or to at least to put on something on the record that would counter those?
Well, the only party that had a chance to put something on the record was the appellant, and that was by way of an affidavit and the motion that was submitted. My client, the appellee, had no specific knowledge other than what was put forth in those documents.
And that is all that was before the court as well, correct?
That is correct, Your Honor. And the court held that that was insufficient to establish good cause, and his findings are on pages, appendix pages 31 and 32. He pointed out that Ms. Weeks did not give a time frame for when she reached out to Attorney Roan's office. He pointed out that she did not make any effort to reach out to either the Superior Court Clerk's office or the Supreme Court Clerk's office to determine whether any case was pending. He pointed out the insufficiency of what was pled and asserted, and he assumed the truth of that, and he said this is not enough. So I think the appellant fails to meet the burden that it has of showing an abuse of discretion requiring that Judge Malloy's opinion be reversed.
Okay, thank you.
Thank you, Your Honor.
Mr. Dahl? You may proceed. You're muted, so it's unmute.
Just wanted to take 2 seconds here to thank the court for the opportunity to speak to you today. It's my first opportunity to appear before the Supreme Court. Got 2 small issues here. One with regard to what the appropriate standard of review is. In the notice of appeal and the way that it's been briefed to the court, appellants specifically couch this in terms of an abuse of discretion. Certainly, as if Attorney Hunter describes the appropriate standard as one of abusive discretion. I'm sorry, we've couched it in terms of legal error. If the standard is one of abuse of discretion, then very well, the appellants may not have made the appropriate showing. However, if you look at the court's decision and how truncated it is, specifically when you're looking at paragraph 45 and the various factors that are outlined by Rule 6b-1, it's quite clear that the Superior Court didn't undertake the sort of fulsome analysis that 6b-1 prescribes. So these are all permissive factors, but it lays out about 8 different things that you can consider. And Judge Malloy abruptly truncates it and says, look, I think this, as a legal matter, it's game over after 2 years. I don't need to really go into the broader analysis. I think from this court's perspective, I think that the safer route is to find that this is a legal error rather than a ruling on the facts, and give it another opportunity on remand to see if we can't get this out the right way. The second thing, I want to note the big differences, the crucial differences between Federal Rule 25 and the Virgin Islands Rule 25. And appellants are not asking this court to rewrite the rule. The federal court rule is written deliberately, and so is the Virgin Islands court. They're very different in their approaches. But there's one critical thing about the federal rule that's different from the Virgin Islands rule that sort of facilitates or would lead to these sort of inequities that I addressed at the outset. Under the federal rule, you have 90 days to seek substitution. And it's from the time that there's a notation of death on the record, but that doesn't end it. There's also an obligation for that notice of death on the record to be sent out to the heirs, to the people that would be the successors in interest. And so in this example of Ms. Tamika Khan or Mr. Prime or Mr. Metivier would need to be put on notice that there is a filing in the Virgin Islands Superior Court, that there has been a notice of death, and that they have 90 days to take some sort of action. That's a big distinction. With a stopwatch running based on the record that's before this court. And when you don't know the stopwatch is running against you, it's tough to be able to act timely when you don't even know that stopwatch is there. But also I want to draw one final critical distinction here. is that in the federal Rule 25, it says that the motion shall be filed within 2 years. And it goes a step further than the Virgin Islands rule. It says if you don't act within 2 years, the case shall be dismissed. And it's not permissive language as Rule 25 is in the Virgin Islands or Section 78 is. It's quite mandatory. The action must go away. However, as the District of the Virgin Islands has said, is that even in the federal system, the federal Rule 6b is not so unforgiving to completely take away any sort of equitable outcomes or equitable options. Even in the District of the Virgin Islands, even if you miss your mandatory 2-year window under Rule 25, you still have an opportunity to make a Rule 6b showing. So at bottom, Your Honor, I think that I want to come back to the remedy that we see.
Attorney,
Yes,
there's something that I noticed because you're making a comparison between both Rule 25s. I noticed something after looking at our Rule 25 so many times. And if we read it, it says if a party dies and the claim is not extinguished, the court may. Look at that word may, because it becomes crucial later on. May order substitution of a proper party. A motion for substitution may be made by the party or by the decedent, successor, or representative. And then the last part is what caught my eye. The motion may be granted at any time within 2 years after the death. So if it said may, does that may in that last sentence of Rule 25 allow Rule 6b1 to seep in and for us to consider for good cause shown, as opposed to over in the federal rules where the last part is said that the action by or against the decedent must be dismissed. Does because of the language this may in our Rule 25 the Virgin Islands Rule of Civil Procedure, does that allow Rule 6 of our Virgin Islands Rules of Civil Procedure to seep in under for good cause shown when and then since that it allows it that rule and further on that the substitution, the issue of substitution is not covered in the under the exception under Rule 6. So that makes a difference as opposed to must over in the federal rules.
I think it does make a difference, Your Honor. I want to kind of switch things on you though. Rule 6b1 says you can do it. Rule 6b2 says there's certain things you can't do. And the only other exception that would be possible is if there was a clear textual commitment in Rule 25 that says you also can't do it here. And there's nothing in here that would say you can't get 6b relief under Rule 25. And may I address just real quick the absurd result that might happen. Let's say that 1 year, 11 months, and 25 days goes past and a motion to substitute is filed. Under just a very plain reading of this, if that motion is, if the judge sits on that motion for 8 days, substitution is not proper.
Right.
So we got to be kind of careful about how we read the may.
All right, but look at this, attorney. Basically, so what I understand is that because of the language of our Rule 25 and our Rule 6, it seems to have a lot more saving grace because of the may language used there than under Rule 25 of the federal rules. The federal rules, you are truncated, you are cut off because the case is dismissed. But was that a basis, was there a reason why when we read our Rule 25 and Rule 26 and the language of may as opposed to must over in the federal rules, does it allows I won't say derelict, but a tardy plaintiff's representative, successor, or whatever to come into court?
Short answer, yes, Your Honor. I think it is more forgiving in the system in the Virgin Islands, and that's appellate's position is that remand and get the standard right before the Superior Court is the way to go.
Okay, thank you. The matter will be submitted. Thank you all for attending. That concludes today's calendar.